Will Fubara gain redemption over unconstitutional suspension and Rivers State? Justice over the state of emergency declared. Crisis looms as 11 PDP governors drag President Tinubu's government to the Supreme Court over the controversial suspension of Rivers State's elected officials, with 12 senior advocates, including a former AGF, now defending the FG's bold move. Could this set a dangerous precedent for democracy in Nigeria? In a legal clash that could redefine the boundaries of executive power in Nigeria's federal system, the federal government has assembled a formidable team of 12 senior advocates of Nigeria, SANs, led by former Attorney General of the Federation, Chief Akin Olujinmi, to defend President Bola Tinubu's controversial declaration of emergency rule in Rivers State. This dramatic legal development comes as 11 People's Democratic Party, PDP governors, challenged the president's March 18, 2025 proclamation, which suspended the democratic structures of Rivers State, including Governor Siminalayi Fubara, his deputy Ngozi Odu, and the entire State House of Assembly, replacing them with the sole administrator, Rear Admiral Ibaket Ibas, Ridi. The National Assembly, in a contentious voice vote, swiftly ratified the executive decision. Now, the Supreme Court is set to determine whether a president in a democracy can lawfully oust elected state officials and install unelected appointees, all under the banner of emergency rule. Now, let's look at the case step by step. A constitutional earthquake in suit number SCCV 329, 2025, the 11 governors from Adamawa, Enugu, Osun, Oyo, Bauchi, Akwa Ibom, Plateau, Delta, Taraba, Zamfara, and Bayelsa are not only contesting the legality of the emergency declaration, but also posing weighty constitutional questions. Chief among them, can the president suspend governors and legislatures without violating federalism and constitutional rule? Their petition seeks 6 fundamental legal clarifications, including whether a state of emergency permits the president to override elected offices, whether the National Assembly can validate such a proclamation without a 2/3 majority vote, whether the Attorney General's threats to do the same in other states breach constitutional safeguards. They are asking the Supreme Court to strike down the emergency rule, declare it unconstitutional, and issue a perpetual injunction restraining any such future action across Nigeria. The government's defense: a state in crisis. In a preliminary objection filed on May 9, 2025, the federal government urged the court to dismiss the suit entirely, arguing it falls outside the Supreme Court's original jurisdiction as per Section 232(1) of the 1999 Constitution. The AGF's legal team, led by Chief Olujinmi, labeled the suit hypothetical, academic, and an abuse of court process. But more pointedly, in a counter-affidavit by Taiye Oloayed, Special Assistant to the President on Arbitration and Drafting, the government painted a grim picture of Rivers State, legislative gridlock, a governor accused of demolishing the assembly building, and militants allegedly threatening opponents with violence, all culminating in what Oloyede described as a breakdown of law and order. The crisis reached a point where governance stalled. The governor could not present a budget, the assembly was split and dysfunctional, and economic sabotage was rampant, Oloyede stated. The government's position is clear. Tinubu acted to preserve democracy, not dismantle it. The suspension of the state's elected officials, they argue, was a necessary evil to restore peace and order. National Assembly joins the fray. The National Assembly, named as the second defendant, also filed a preliminary objection on April 22, 2025, asking the Apex Court to dismiss the suit and award $1 billion in costs against the governors. Lawmakers argued the plaintiffs had no locus standi, failed to follow due process, and did not suffer any unique injury beyond that of ordinary river citizens. Further, they claimed the governors did not obtain required approvals from their respective state legislatures, nor did they serve the legally mandated pre-action notice to the clerk of the National Assembly. Procedural failings, they say, render the case dead on arrival. Precedent in the making. As Nigerians await the Supreme Court's decision on whether to hear the suit, the stakes are immense. This case is more than a political squabble. It's a constitutional test of Nigeria's federalism, the limits of executive power, and the resilience of its democracy. If the court upholds the emergency rule, it could set a precedent empowering future presidents to override state authorities during crises, real or perceived. If the court strikes it down, it could reinforce the sanctity of democratic institutions, no matter how turbulent the politics. For now, one thing is clear. Democracy in Nigeria is not just being practiced, it is being litigated. And the verdict could echo far beyond the boundaries of River State. Yasu, so, what do you think? Does a political crisis justify the total shutdown of a state's democratic institutions? Will Fubara eventually win this case, or this is just a waste of time? Drop your thoughts in the comments, and don't forget to like, share, and subscribe for more updates on this matter, as we look forward to seeing you on our next video.